Yes, Mr. Gill.
I'm great. 10:16. I'll do my best to finish within as little time as possible. My lords, the bundles that I'm going to, that I refer to now, skeleton argument, are SAA bundles. They're labelled as Volume 1, Volume 2, and Volume 3. But that was before the bundles were all given their unique numbers. So wherever you see SAA Volume 1 or Volume 2 or Volume 3, you have to read 16, 17, or 18.
Thank you.
And the court authorities that I will refer to, I may not need to turn them up, but just so when you look at my submissions in due course, they are in Volume 19, mainly in 22, one in 21, so Gazuli. The Data Protection Act, strangely enough, seems to have been omitted from the court authorities, but these things get overlooked. It is now in Volume 29. But I'm obviously not going to have time to go to those. That's just for your housekeeping.
Thank you.
4 very brief preliminary points. I'm sure everybody is aware that this is a rolled up hearing, but of course on the basis that I'm only being allowed to advance short points and an equivalent of permission hearing, and will only develop them to the extent the court needs to hear further or wishes to hear further. It may be that other directions then have to follow in due course at some point. The second point is, you asked a question yesterday to somebody, I can't remember who, about statistics of persons expected to be removed each year. I think we can say the answer is in our skeleton argument at footnote 31. I don't need you to turn it up, because I'm going to have to go so far. It is a cross-reference to the Data Protection Impact Assessment, which is Mr. McGinley at Exhibit JM13, SAA Volume 17, tab 47, page 1222, where he says published statistics show that 9,620 asylum claims were identified for consideration of admissibility grounds in 2021, and so for indicative purposes only, we should expect a similar number this year, which is why the Prime Minister then said tens of thousands each year. There is, it was actually based in numbers. There is also at volume 17, tab 47, page 1211, similar acceptance within the same data protection impact assessment, contrary to the respondent skeleton, but this is large scale. Question 8, data protection impact assessment, volume 17, page 1211. Still on this point, there's a letter from the PM's office which talks of at least 10,000 per year. This is in SAA, volume 18, tab 53, page 2343, line 4 near the top of the page.
Sorry, could you say that again? I didn't quite catch it.
SAA, volume 18,
Yes.
tab 53, page 2, electronic, page 2343, line 4 near the top. So they're talking about tens of thousands, and they're basing it in the numbers, in actual numbers. The third preliminary point is that a question arose about the number of lawyers in Rwanda. There's some information about this, helpfully, in the AAA KVD skeleton argument at para 129, and also in other parts of the AAA skeleton arguments below and here. That's worrying enough. Our concern is that there is no information at all about data protection lawyers. No inquiry has been made on this, no evidence obtained, and data protection law is difficult enough. But here, it is nascent, to say the least, in Rwanda, with the data law having been rushed through in October 2021 because this deal was about to be put together, with a 2-year rollout period, which is still not finished. That is in Mr. McGinley's statement. The 2-year rollout period reference is in Article 67 of the Data Protection Law, which Mr. McGinley exhibits in his witness statement. I'm going to have to do this very fast, I'm afraid. I then turn to my general submissions. Our submissions fall into two broad heads. Those two broad heads are this, that the DC erred in concluding that the data issues were irrelevant to essentially any public law decision, relevant here. And secondly, they erred in failing to understand or address the data issues, other than really in passing. And it's that failure to understand what data is all about which infects their reasoning on the first issue, because they just think this is not relevant to 345A to D, because they don't understand the data issues, because they didn't allow me the time to develop the issues. This would have been a 2-day case, as I always said, and I always said it should follow on or be heard with AAA, because I needed their evidence on how the risks were and surveillance of journalists, of the state activity, and we didn't have the resources in our small, very limited team to do that, which is why it had to follow on from AAA. So I was content to be always heard separately, and if you want a full hearing after this permission hearing, you could always hide this case off to a separate hearing, 2 days in the Court of Appeal in the next few weeks or something. Now, one needs to address and understand the data issues in order to understand their link with the decisions in 345A to D in the context of Article 3 and Article 8 risks. In short, putting it as shortly as I can, the assessment of safety in Article 3 terms of the country of proposed removal, 345B question, and the assessments of Article 3 and Article 8 risks, 345C and 345D questions, all involve a global assessment of the human rights laws and actual practices, experience, ability, track record of the allegedly safe country. That, I use those words because when you look at cases like Schrems in due course, you'll see that sort of language in the data protection law cases. You might think that sort of language is really what Mr. Hussain is talking about, rightly talking about. So it is. But it's also the language necessary for data protection assessments. Why? Because in the modern world, it is the risks arising from the misuse of personal data by states and state invasions of privacy of persons, surveillance, monitoring, communications, and so on, which poses the greatest threat to fundamental freedoms. Despite the rush to embrace modern technology, this poses the greatest threat to fundamental freedoms. The targets are not just those whom states wish to control or to silence or to bump off or to kill. They're also people who they want to check what are they saying on WhatsApp with each other. What are these returnees saying about their conditions of detention? How might this impact upon us in terms of our relationship with the UK under this MOU? Are we going to look bad in due course or not? So when I was refused permission to put in evidence, and we put in a large amount of evidence about violations and risks of this sort, and we were refused, we haven't appealed it because, as I said, somebody on our side didn't manage to get the transcripts or the evidence or put in the notices, and I was stuck before Lord Justice Underhill in not being able to, as you'll recall, appeal against that. Water under the bridge doesn't matter because the evidence is there in the such as I need it, is there in the AAA bundles anyway, and it is also in Mr. Tawfiq Hussain's witness statement, which is also attached in SAA volume 16 at page 694 or following. He's talking about the sort of things that Mr. Hussain was talking about oppressive state and so on. It is in that context.
Mr. Gill, I'm sorry to interrupt, but it's a question, you've only got half an hour. It's a question I would like you to answer in the course of your submissions. It would help me. If we were to determine that Rwanda is not a safe country, as the other appellants have argued, what do your submissions on data protection really add to the case, and do they really make any difference? Do they need to be determined? And the second question is, if we were to determine that Rwanda is a safe country, then surely that undermines much of your submission about the data protection issues.
The reason why you need to determine it is that let us assume that Rwanda is safe in the Article 3 sense.
Yes.
In terms of how it impacts, how they treat people. You may not, of course, be able to reach a conclusion on that in the absence of looking at their data practices. But you may not. But if you were to assume that it was a safe country for Article 3 purposes, it may still not be a safe country for Article 8 purposes. And remember, for Article 8 purposes, this is the primary vehicle through which data comes in. Because Article 8 ECHR, text data rights, cross-refers to Article 7 and 8 of the EU Charter. This is where GDPR comes in. So if this case were to end up going before the European Court of Human Rights, in the context of Article 8, I expect them to apply all the union law in relation to the GDPR, which we are required to apply also because of Article 71 of the withdrawal agreement, which is referred to in our skeleton argument. And the point is that because Article 71 of the withdrawal agreement requires us to maintain an essential equivalence in terms of data protections with the EU, even post-Brexit, whether Rwanda is safe in Article 3 terms or not, if it is unsafe in terms of the protection of data to the standards required by the GDPR, we would still win on Article 8 grounds. That's Article 8 ECHR grounds. And so...
Is there any decision of the Strasbourg Court that it is contrary to Article 8 for a person to be removed to a country outside the scope of the convention where privacy rights are not protected to the standard that they are in convention countries?
Oh, there isn't yet, because there hasn't needed to be such a...
No, okay, I just wanted to know, this would be... you.
Absolutely.
You have to say it's analogous to cases like MSS or Suring, a better example, is outside the convention.
I'm not talking about Article 3.
No, I know you're not, but you're effectively applying...
Sure.
And you're saying it's a breach of Article 8 by this country to remove someone to a country where Article 8 rights are not respected. And that is by analogy, as I understand it, with the case law on Article 3, because as you said, there's no such case law on Article 8.
It's a little bit more deeper than that. It's not, I don't need to actually rely on analogy with Article 3. This is what I want to... The point is that we are supposed to, post-Brexit, apply an equivalence of standards with the EU. We've maintained that. And when you read the Schrems cases, you will see that this wasn't about Article 3. This was about violations of data in the United States. So I don't have to tie myself to an Article 3 standard at all. That's why I emphasize Article 8. It may become clearer, because I've only got another 17 minutes or so, if when you read the cases, you'll understand why, and fully understand the effect of Article 71 and Section 7A of the Withdrawal Act 2020, which requires us to maintain that standard with the EU. You'll understand why. This isn't really, my case isn't about Article 3, really. I
have your point.
Yeah, okay. This is therefore at the very heart of the inquiry for 345A and 345D purposes, for the reason I mentioned, and also for another reason, namely that you actually can't, in practice, send a person to Rwanda without those data protections to an equivalent standard being satisfied. This is what the MOU in effect says, because they're meeting the they purport to meet the TPA standards. It's completely non-binding. It has no force whatsoever, not enforceable in international law or in the law of this country or in the law of Rwanda, but that is what they wanted to do, rightly. They wanted to do that because they recognized exactly what I'm saying, that they needed to ensure compliance.
So
Now,
your submission is that the UK can't send a person to Rwanda without being satisfied that Rwandan's GDPR meets GDPR standards.
absolutely.
So the proposition is that nobody can be removed from the UK to any country where the standards do not meet GDPR. That must follow.
You have to check, and you have to decide on what those standards
No,
are.
but just assume you check and
Well,
the standards don't meet up. Is removal then prohibited? It must follow, surely, that that's your submission.
Yes, but the answer to that question is that it doesn't actually pose a problem in a large number of cases. And the reason why it doesn't pose a problem in a large number of cases is this, and this is why you really got to understand the data law in order to understand this point. And but if I can summarize it very briefly now, it is this, that in a lot of those standard removal cases, if I can call them now, what are they? They're people who've come from their own countries. They've presumably signed some sort of an application form when they've come from their countries, say a student or somebody or other comes here, then overstays here, they're going to be removed. They will have given their consent already to the use of their data at the point they've actually applied from abroad. Supposing they come without anything, somehow manage to get on a plane, there are difficulties, they arrive here, they're just turned back, they're just going to be sent back to their own country. They're not raising any human rights arguments. And in the even if they're in country, if they've been given, and this is where the Article 13 and Article 21, it's not just Article 13, Article 21 of the GDPR, which is relevant. If they come here, they may be interviewed, they will be given a notice, and they will be told that your information may be used for all sorts of other purposes. Now, if they give their consent or they don't take the opportunity to object,
that doesn't meet the point, does it? If your point is that when they go back to Mauritania, they may have an unfriendly government monitoring their WhatsApp messages and so forth, doesn't matter what forms of consent they've signed over here.
no, it
Still
does.
sending them back to somewhere where their Article 8 rights will not, that their GDPR equivalent rights are not respected.
No,
Misunderstood you?
there are different elements of the process, which is why it's so impossible to do this so fast. There are first you get their information, you give them the notice about objection and the right to object. You give them the right to object. If they don't object, that's the end of that story. You can then therefore transfer the data under Chapter 5, Article 49, let's say. You can transfer the data. And we're talking about transfer of data. We're not talking about what your lordship is talking about, which is about substantive violation type arguments in Article 8. I'm having to say this so fast, it's going to get garbled.
Well,
No, but that's what you were talking about a moment ago. You
Yeah,
were,
I know.
I think, submitting that it's not just a question of transfer of data, but that once somebody was in Rwanda or Mauritania, as my lord hypothesizes, then there would be Article 8 breaches because of a failure to have appropriate data protection laws.
I'm sorry, that's because that's our case.
Yes.
But you then asked me about,
Right.
I think we were also talking about all other types of cases.
Right,
Doesn't necessarily follow in all other types of cases.
Well, we keep the distinction in mind that
Yeah.
there's A, transfer of data, that's what one argument, B, the data environment, if I can call it that, in the receiving country.
Yeah,
Okay.
so if I can proceed in this way, so far as the decision making, well, I don't think I'm going to have time to even set out what the decision making process is between in the context of 345A to D, where you have to make the assessments in the 345B. You don't actually make the actual final decision, although you make a notice of intent, which is a sort of a decision, like a minded to refuse decision. And you don't make the 345A decision until you've actually done all the other checks. So the whole process comes together, which is why the data assessment, as they themselves realized when they wrote the MOU, had to be written into the MOU, which is therefore essential. But, you know, this is no way to advance these arguments. If I can just, in such a limited time, if I can then just go to the actual points about how the GDPR works. You have the UK GDPR, which is the law that applies in this country. It's essentially become retained from the EU GDPR. When you look at the structure of the EU GDPR, it has certain headings which appear not to have been actually put into the version that we've got. I've still not been able to find an official UK government version of the UK GDPR. This is referred to in our KVD skeleton argument, that people are not going to know where to find this. What's happened is that various private database providers have managed to put this together. And so the headings don't appear. But when you look at the structure, chapter 1 is just introductory, and then chapter 2, articles 5 to 11 are principles. Chapter 3 is then 12 to 23, and I asked all of those to be looked at, not just Article 13, deals with the rights of the individual. That applies to everything. Then you have the controller and processor points. They are in Articles 24 to 43, and Article 26 is relevant because of the joint controller argument, which we say there are joint controllers here. And then we have Chapter 5, which is 44 to 50, which is important. And then Chapter 6 deals with supervisory, and Article 52 is important because of the need for an independent supervisory body, and there isn't one in Rwanda, as we pointed out. So if you were to complain about what were happening to his data, whether some security official on the RSDC had taken it away, a hard copy in his bag, and put it somewhere else, whether he'd sent it to the Sudanese, to the Rwandan embassy in Sudan, how is he going to find out all these things? Who is he going to complain to? There is no supervisory body, and independent supervisory body in Rwanda, as explained in our skeleton argument. You've also heard that there's the arguments about the lack of an independent judiciary. Who is he going to complain to? There's no evidence of a single data protection case in Rwanda being conducted. Now, you heard about the refugee law cases. There's not a single data protection law. There's no evidence of a data protection law, as I said, on the evidence. So all we've got, according to the assessment made by the Secretary of State, is the MOU and one or two follow-up inquiries, which are only about where will you keep this, in what form will you keep this, pro forma type stuff, which box are you going to put it in? That's Krellin witness statement, paragraphs 24. I'll give you that reference when I get to it in due course. I have it, but I'm jumping ahead of myself. So we have, there has to be that structure. The data protection impact assessment, when you look at it, and it's here, I'm not going to have time to turn up the authorities, so I'm just going to read it out to you. It's core authorities, volume 19, tab 11, page 162. It's article 35(7), UK GDPR, which says the assessment shall contain at least a systematic description of the envisaged processing operations, at least, and the purposes of the processing, etc. an assessment of the necessity and proportionality of the processing, an assessment of the risks to the rights and freedoms of the data subjects, the measures envisaged to address the risks, including safeguards, security measures, mechanisms, and so on. In other words, they're exactly the sort of things that you'll be thinking about in an Article 3 case, but this is looking at it really from an Article 8 perspective. And in other words, there's got to be a fulsome assessment, rigorous inquiry. All the earlier points apply here as well, because the context of this data is about asylum seekers. To what that country's data protection regime is. Now, that's 35.7. Now, I said that Chapter 3 rights, which I'll come back to in a moment if I have time, are all about the rights of the subject and the notices the subject is to be given, which we say haven't been followed. We say Article 13 has been wholesale violated, contrary to what the Court of Appeal, Divisional Court held. It's important that I just read out just one part of it, which they did not even address, and it is in Port Authorities, Volume 19, Tab 11, page 121, at 13.1f. One of the things you're supposed to give on the notice is whether it says, and you said to do this, the existence or absence of an adequacy decision. There isn't one by the EU in relation to Rwanda, but now we have to do it ourselves. If we're going to do one under Regulation 17A of the data, we haven't done. It says the existence or absence of the relevant adequacy regulations under Section 17A of the 2018 Act, or in the case of transfers referred to, you see the structure, in Articles 46 or 47, or the second paragraph of Article 49.1, reference to the appropriate or suitable safeguard. No notice is ever given along those lines. But the reason why that's mentioned in Article 13.1f is precisely because they're emphasizing the importance that you've got to think about, are you going to make an adequacy decision or are you not? And when you go to Chapter 5 rights, these are dealing with international transfers. Chapter 5 rights start at page 184, the same bundle. You will see how the structure works. I think I'm going to claim my 36 minutes, if I may. Up to 28 at the moment.
Well, I think we started a minute late, so you've got a minute or two more. Lord Panic won't be too upset by a minute or two.
My Lord, Article 44, page 184, any transfer of personal data, etc., the last few words, in order to ensure, the word is ensure that the level of protection is guaranteed. Nothing ensures here. There is no binding legal instrument. There's a footnote in my skeleton argument where Lord Justice Singh, in a different case, talked about the need for a binding legal instrument. You'll see that in a footnote in my skeleton, and rightly so. There is no binding legal instrument here. Article 45, page 186. These are adequacy decisions. You see 45.2a. When assessing the adequacy of the level of protection, you have to do all those things that you would do in an Article 3 type case, the Ilias type inquiry. When you look at article, if you can't do that, you've got to bring your mind to bear on it. If you can't do that, you've then got to go to Article 46. So we know Rwanda's unsafe. It's not going in data terms. There's no adequacy decision, and we can't go to Parliament, therefore, to make the regulations under Section 17A of the Data Protection Act. We're going to have to think about something else. Let's try Article 46. Article 46 at page 191 says, well, you can still do it, but you would have to put in appropriate safeguards. They don't do that because they recognize there aren't even appropriate safeguards they can put in. They jump straight to Article 49. And we say, no, you've got to look at why it is that you are not going down Article 45 route, why you're not going down Article 46 route, because if you do that as a public law decision maker, you will then recognize what is the shortfall of the standards that Rwanda should be meeting in this particular case. You haven't even done that. They say, we can choose any one of these things. We can either go under 45 or 49. No, you can't. You've got to go by way of a structure. They didn't do that. So on classic public law grounds, they just haven't carried out the inquiry. They jumped straight to Article 49. But even if they jumped straight to Article 49 and they've said, it's necessary, the transfer is necessary for important reasons of public interest, page 198, Article 49(1)(d. This says, 49(4), the public interest on 199 must be public interest that is recognized in domestic law, whether by regulations under section 18(1) or otherwise. In other words, you've got to have national law, not a policy, not an immigration rule, but national law, and it's got to be clear, and it's got to be clear. You can't just say, oh, we've got general powers to remove under the Immigration Act 71, and that's enough, which is what they're saying. And they say that in order to avoid going to Parliament. And the reason why this is important, why the fallacy of their argument is we say, demonstrated, is by section 13 of the Immigration and Asylum Act 1999, which is in the same bundle at tab 2 at page 8. I think it's tab 2. You'll see that this talks about removing of persons to a country of which they are nationals. Now this provision, section 13, was there. What did they do when the Data Protection Act came in? Rightly, they set out the relevant public interest in 13(4) by way of amendment by saying, for the purposes of Article 49(1)(d), the provision under this section of identification data is a transfer of personal interest which is necessary for important reasons of public interest. In other words, to transfer a failed asylum seeker to their own country of origin requires, and there's a public interest in that, that public interest is specifically expressly articulated in an Act of Parliament. Now that they've come up with a completely new and novel, radical scheme for the first time to go to transfer people to an allegedly safe third country, bypassing Parliament, the 2004 Act arguments that we hinted at in our skeleton, but and our grounds, but left others to develop. This is also bypassing Parliament, and I probably have to finish very shortly, but what they are doing here, what we say is, Parliament would have expected, in relation to removal of someone whose asylum claim you're not going to determine, and you're going to remove them to a country you say is safe, but he objects to, Parliament would have expected the relevant public interest to be identified in a legislative measure. And they've given you the mechanism under Section 17, under Section 18. Why on earth did you not choose it? You can, in urgency cases, when you look at Section 18 in the Data Protection Act, of course, Section 18 has processes for the made affirmative resolution procedure, so that, in an urgent case, you can actually pass the regulation. Here, they were so concerned about getting people on that plane, which is why we had to issue for judicial review in that fevered atmosphere in early June last year, and in the run-up to it. They just bypassed Parliament altogether, didn't do what they should have done under Section 18, which is to put the regulation before Parliament to say, Parliament, we're going to actually send people to Rwanda. We think there's an important public interest in this. This is radically new, and we are therefore going to identify this as an important public interest. Please sanction this in this regulation. And because we don't have time to wait for you, we're actually going to go through the made affirmative resolution procedure, which means we'll assume it's made until you're aware of that procedure anyway. They didn't even do that. They don't actually claim the urgency. But they acted urgently, and this is the abuse with which they've acted. They acted urgently in order to get people on that plane when none of us had the opportunity to actually take instructions from our clients and actually make put points to them. And that is why the Article 13 rights are so important. The Article 13 rights have got to be 12 and 13 have got to be, and 14, but we're talking principally about 13. There's no evidence. You'll see none of the evidence in our case is actually disputed, and that must have happened in every other case. They're not given any privacy information notice at the time of the screening interview. It's a telephone interview with an interpreter. How on earth is an interpreter going to transfer a URL link? The data is taken from them. They have no right to object, and everything happens so fast. And they say, oh, well, we can give you the privacy information notice in due course if you ask for it, a hard copy, and so on. None of our evidence, SAA's witness statement, Mohammed Mohsin's solicitor's witness statements, which I would ask you to read with care, are actually objected to. And that must have happened in every other case as well. So what is the point of Article 13, therefore? It's not just to give you a notice and just leave it there, which is what they're doing. And they relied only on the general privacy information notice, which they gave to every other person, which doesn't deal with Article 13, or indeed any of Article 13, contrary to what the Divisional Court said.
But the Divisional Court were with you on Article 13. That's not why you lost.
On part of it.
Okay, but that's not why you lost. You lost because they said it didn't impugn the public law decision.
Well, I've already said why these matters are relevant to public interest. But if I can just say that then what you've got to do, what's the purpose of that, is to, Article 21, you've got to be given the right to object to this. He was never given the right to object. This is why the asylum aid arguments were so important to us as well. When I made this point to Lord Justice Lewis, he said, well, you're in a better position, aren't you? Because you don't actually...
We need to focus on the arguments why you submit permission should be given on this point. And you're moving into sort of rather wider forensic arguments.
Well, I've already made my point that how are you going to be able to carry out an objection, raise an objection to the country's data law practices, and what they do with your data and so on, if you aren't given a proper notice before the data is collected and given adequate time. In our case, the data was transferred on a bank holiday weekend, even before the 7 days was up. So that's the article, chapter 3 arguments, and they're set out in the skeleton argument. In terms of the data, lastly, if I just take, I hope only 2 minutes or so.
2 minutes.
In relation to the data protection impact assessment, you will see that the data protection impact assessment, their own data protection officer said she's very uncomfortable with this, and we've given all the cross references, and said we're not meeting the standards. The emails show all this. Their own documents show that there had to be an escalation up to their data board. They never escalated up because, as the witness statements Mr. McGinley shows, there was basically a standoff. And that's where it lay. So there was no proper data protection impact assessment. If there was no proper data protection impact assessment, how on earth could there be a proper Article 3 assessment of safety? How on earth could there be a proper Article 8 assessment, irrespective of Article 3 tests? Well, Lords, these arguments are rather more complex than I can actually get across in the time available. I'm conscious that I think I've only gone about 3 minutes over my 36 minutes.
Well, thank you. I mean, we should emphasise that your skeleton argument is a detailed document which we have, and all the references that you invite us to look at are set out in that document. All right. Well, thank you very much indeed, Mr. Gill. James, you're going first.
I think I'm going to go first, yeah. I'm going to deal with safety in Rwanda, effectively. That is going to cover grounds of appeal numbers 1 to 7 inclusive. And then Lord Panic is going to deal with the rest, with the exception of data protection, which Mr. Hopkins is going to deal with, if the court requires assistance on that issue. My submissions are going to focus principally on the system in Rwanda, and in particular the risk of refoulement. That's going to be the first section. Then I'm going to deal with the general Article 3 risks in Rwanda, including concerns about the substance of Rwandan law. Merge those two together. Then, as the third topic, I'm going to deal with Ilias and matters procedural. And then finally and shortly, I'm going to deal with what's referred to in the judgment as the Gillick issue, which is ground 6 on the list of issues. When I give you references to documents in the documents bundle, I'm going, I think, with about 1 or possibly 2 exceptions, going to be giving you references into the common documents bundles, number 1 to 5. So rather than me saying common documents bundle, I'm just going to give you 1, 2, 3, or 5 as the reference, if that's acceptable. And it may give the court a little encouragement to know that every document that's been referred to from the myriad of files you have before you so far in this hearing fits actually in the end within one lever arch file, leaving authorities aside which themselves, as referred to, fit within one lever arch file. So I hope you won't be burdened with too many documents, but that's what I'm going to do with references, if that's acceptable. I wanted to start by making 6 important, I respectfully submit, important initial points, and I'm going to return to the detail of most of them. First of all, this is a bespoke scheme. The purpose of the Memorandum of Understanding and of the Note Verbal, together referred to as the MEDP, is to provide assurances that the United Kingdom can safely transfer individuals to Rwanda for the processing and determination of their asylum claims there. It has, as you will be well aware, and as the Divisional Court pointed out, very significant safeguarding elements specifically built into that scheme. It's designed not merely to assure processes, but also to deal, in significant part, with the various concerns that have been identified, including by UNHCR. See, for that purpose, Armstrong, he'll forgive me for not putting Mr. in front of his name, Armstrong 1, paragraph 16, Roman 2, which is in bundle 3, tab 26, page 1017. The core elements of those documents, of that MOU and those note verbal, and there were 2 note verbal, as you're aware, are conveniently set out in key parts, although there may be other bits that we'll have to refer to as I go on that aren't referred to here, but they're referred to in key parts and quoted in the Divisional Court's judgment at paragraphs 18 to 27, with the core elements then identified and returned to by the Divisional Court in paragraph 57 of their judgment. That's the first point. But secondly, it is a scheme which both governments have a very strong vested interest in making work satisfactorily and as intended. And by satisfactory and as intended, I mean in a way that is lawful by reference to the standards in the Refugee Convention and in the European Convention on Human Rights. And Rwanda, of course, is a respected sovereign state, which is a signatory to the Refugee Convention, to UNCAT, the Convention Against Torture, and is a member of the Commonwealth. It isn't, of course, a signatory to the ECHR. Some reference in some of the submissions to the idea that Ilias might apply to Rwanda directly, but of course it doesn't because they're not a signatory to the ECHR. But thirdly, in addition to that degree of respect for such a country, there are serious reputational issues at play
in this context, especially given the publicity attendant on these reforms and these arrangements, and given the specific interests of UNHCR in these matters. There are financial incentives that are built into the arrangements, and there are processes within the arrangements that control the flow. You've seen specific reference to those in the Divisional Court judgment. In effect, Rwanda has to consent, pre-consent, to individual cases being sent to them.
Can you just help me with this? I haven't picked this up. We don't know the details of the financial incentives, do we? So we don't know whether there's a financial incentive on Rwanda to...
I'm going to come to them very specifically. There are some built in, we know some of them. What you don't have is the note verbal dealing specifically with the details of each individual case, but you do have some numbers, and I'm going to give you the references when I get there. They're principally an Armstrong one, but I'll be assured I'm going to cover that, because the suggestion appeared to be made that because we haven't had the financial note verbal, you can't place any reliance on that. So I'm going to give you the references to that specifically, if I may. The point I'm on here, the third point I'm on, is that all of those matters in combination provide powerful practical reasons for concluding that Rwanda will honour the commitments that they have seriously undertaken. But fifthly, and again I'm going to return to this...
Four. I think we're up to 4, Sir James.
But we're on to 4, I'm so sorry, I'll jump down. It's a scheme we submit which falls to be judged in its own context and on its own terms. Whatever debates there may or may not be, whatever controversies there may or may not be about Rwanda's conduct in the past, but we submit is at best peripherally relevant. This is a new context, in significant part designed with some of those specific concerns in mind, but importantly with its own real incentives. Fifthly, it is a scheme which will be carefully and independently monitored by Her Majesty's Government, by the bespoke monitoring committees, to say nothing of the UNHCR's continuing role and observation, and the legal eyes that represent claimants such as these. If things go wrong, or if things go arguably wrong, then we, and no doubt the domestic courts, will hear about it. And sixthly, and the final point in a single sentence, foreshadowing the Ilias submissions that I'm going to make in detail at the end, or towards the end, it is a scheme, and Rwanda as a safe country was an assessment that was considered with conspicuous, perhaps unparalleled, care and thoroughness by the United Kingdom government. And that, of course, has been topped off, as it were, by the degree of consideration that has been given to these issues and all the myriad of points that have been made and taken by the Divisional Court and by this Court. On top of all those 6 points, it is, of course, the fact that this is an appeal. The case was one in which the Divisional Court had, and evidently took considerable care to go through, the mass, perhaps morass, of detail and evidence. And it is trite that at this level, assessments of fact are to be respected. This court does not provide claimants with an opportunity for, in effect, the de novo mounting of arguments about facts. Can I just take you to a couple of very short extracts from some authority on that issue, both from the Supreme Court. The first one is Lord Kerr, and it is in the third supplemental authorities bundle, I'm afraid, bundle 29. we want bundle 29, third supplemental authorities bundle, and I want tab 22 within that, if I may. Which I'm hoping, that you look in particular at the Master of the Rolls, is DB.
Page 394.
Page 394, exactly, it's DB. It's a very well-known passage. And the passages I wanted to remind you of, I'm sure it'll be more than familiar to your lordships, but can I remind you of paragraphs 78 through to the end of 80? Can I just invite you to cast an eye down those paragraphs? I won't read them all out, it'll be deeply familiar stuff. But 78 to 80, if you could just cast an eye down those paragraphs.
Yes.
I think in the next tab, but in the next bundle, tab 23, which is in volume 30 of the electronics, there should be Z and Hackney Borough Council, a 2020 decision of the Supreme Court, with the judgment of the court in effect being given by Lord Sales, and the paragraphs for present purposes are paragraph 56 on page 440, and I go there because, as you will see if you just track forward to paragraph 74, I go there with its long quotation from Lord Justice Lewison in the Court of Appeal, which was the judgment being appealed. In 74, Lord Sales, page 447, Lord Sales effectively agrees with and endorses that analysis. So can we go back to page 440 and paragraph 56, and could I invite you to read the indented quotation from Lord Justice Lewison, starting with paragraph 63 within the quote of the second whole punch on page 440, and read to the end of that quoted section to 442. Again, you probably don't need much of the detail, but you'll see the sense of it and some very familiar principles about how you approach findings of fact by a first instance court which has seen all the evidence, even if they didn't receive oral evidence.
Yes.
You'll see again very familiar, but note the points in particular, paragraph 67 within that quote halfway down 441. The court is bound, less fairly reason to the contrary, to assume that, of course, taken into account the whole of the evidence in its consideration. And then all the analysis of wrong and proportionality, which is all very familiar, and the idea that the appellate court should not interfere, or should accord considerable respect, if that's the right way of describing the idea, even if oral evidence hasn't been given. See 441 to 442, and then go forward, if you would, to 74, page 447. Can I just invite you to read that paragraph, because that's the paragraph, as I said, which Lord Sales endorses that approach.
So could I have the paragraph number again?
74, my lord, I'm so sorry, page 447. Well, those were the introductory and brief submissions. can I turn to the system in Rwanda, including in particular the real risk or otherwise of refoulement. And my overarching submission is that the Divisional Court was correct and or entitled, to use that concept as the flip side of not wrong, to conclude that there is no good reason to suppose that the MOU and the NVs will not operate acceptably and fairly so as to avoid any real risk of refoulement to a state where an individual claimant fears persecution. There are many ways in which the submissions could be addressed. I'm going to try and group them together, my response to the submissions that have been made, under 7 heads, if I may. And the first of the 7 heads is assurances. You're aware of the assurances that have been given and the detail of them in the MOU and the NVs in particular. Our submission is that the Divisional Court was right to conclude at paragraph 62 that ex facie those assurances were or would be sufficient to avoid any real risk of an Article 3 kind. They are detailed assurances regarding both the processing of relocated individuals' asylum claims and the reception and ongoing treatment of relocated individuals. You'll remember there were 2 of the note verbal which dealt with those 2 different topics. So ex facie is the first submission. Secondly, there is, however, strong support in practice for the idea that those ex facie satisfactory assurances will in fact be met, or to put it another way, that the Home Secretary was entitled to rely on those assurances as seriously given by Rwanda. And in relation to the in practice aspect, in relation to this, probably an A, B and a C if I may, the A point is that these are formal documents with specific and clear terms, as the Divisional Court noted at paragraph 65 of the judgment, agreed between the governments of Rwanda and the United Kingdom to record the arrangements that both considered to be satisfactory. You might wish to note also, but perhaps only as a footnote, that there is an explanation in Mr. Armstrong's first witness statement at paragraphs 34 to 37, bundle 3, tab 26, as to why an MOU was positively chosen over a formal treaty, in essence and unsurprisingly, flexibility, speed of implementation, and compliance likely to be assured due to the diplomatic relationship. And as he there also sets out, in due course the intention is for a formal treaty to be considered once the MEDP is up and running. Point B, under this head of in practice, it is, I submit, proper and appropriate to accord respect to the experienced and expert view of Her Majesty's government that Rwanda will comply with those arrangements. That was the considered view of the government is set out in particular in Mr. Mustard's statement at paragraph 20, bundle 3, tab 32, page 1109. He sets out what was the considered view of the Foreign Office when the arrangements were made. But you will also note in this sphere that, as I think my Lord Justice Underhill pointed out, the Home Office are themselves well used to doing assessments about foreign systems and conditions. You will also note that this is a context in which what is required of the government is a predictive judgment. And those are all very well established grounds for according respect. May I give you one reference which supports the proposition that both the government and the courts should not readily infer, as it's put, that a friendly sovereign state will not perform the obligations it has solemnly undertaken. I don't invite you to turn it up, but that's a direct quotation from the Supreme Court, I think, in Yogathas, Yogathas, at paragraph 9, first supplementary authorities bundle number 23 at tab 11, page 252. So it's a broader reason for respect because it concerns the relationship between the United Kingdom and a friendly foreign state. But those other elements that I outlined a minute ago all provide proper bases on which to accord respect. And our submission, in a nutshell, is that the judgment at paragraph of the Divisional Court at paragraph 64 to 66 was right to attach weight to that. My learned friend Mr. Hussain asserts that the court accorded too much respect to the government's judgment about whether or not Rwanda would comply with those arrangements. And our submission, in short and in answer, is not so, for the reasons that I've just given. The classic bases in combination for according respect, or in the Strasbourg case law margin, are made out because of the combination of circumstances and factors that I've just outlined. But there was also something of a difficulty with my learned friend's submission because he appeared to accept in exchanges with the court that full-blown respect, if you will, was to be accorded in relation to judgments about good faith. But he then sought to draw distinctions between that, i.e. respecting the good faith judgments, and an argument about whether or not in Rwanda there would be a proper and safe system and their capacity to deliver that. My submission in answer to that specific submission is that no such distinction is warranted either by the case law or in principle. The bases on which respect is accorded are squarely in play in relation to both aspects. And by both aspects I mean the good faith of the Rwandan government, paradigmatically something which attracts considerable respect if the judgment of the United Kingdom is that they will abide by the arrangements in good faith. But also, those factors are in play but when you're making that predictive judgment about whether or not the system will be capable of delivering the safe outcome that everyone is expecting and hoping for. And for the reasons that I've foreshadowed and I'll come back to, there are plenty of good reasons in practice which support that, that conclusion and that judgment encapsulated in paragraph 20 of Mr. Mustard, which the Divisional Court relied upon. And that's really the third of the points, sub-points under this head, the C point. There are the most powerful practical incentives supporting the judgment that there will be compliance and that Rwanda will deliver. Rwanda knows full well that the United Kingdom expects compliance to ensure a safe, fair and lawful operation of their systems. It's also evident from the, not least from the MOU itself, that all parties were unsurprisingly well alive to the idea that the arrangements would be likely to end up in the domestic courts in the United Kingdom being challenged. And that is no doubt why, I don't invite you to turn it up now, but that is no doubt why paragraph 12.1 of the Memorandum of Understanding itself, page 686 in bundle 3, behind tab 13, so bundle 3, tab 13 is the MOU, clause 12 is at page 686, and it makes specific provision for Rwanda to provide to the United Kingdom any information that it holds upon request of the United Kingdom and without undue delay for the purpose of defending a legal claim brought in United Kingdom court. And that provides the context and the seriousness of the context in which in particular, the concerns raised by UNHCR, which were then put for response to the government of Rwanda and triggered the responses that you've seen, that is the, as it were, the agreed basis, the serious basis on which that information was being provided. But in terms of the practical support for the judgment about compliance, I mentioned earlier the financial aspects of that. That is dealt with in paragraphs 25, or noted at paragraphs 25 and 26 of the Divisional Court's judgment, with their conclusion recorded about the financial arrangements at paragraph 65, and the references to funding that I referred to earlier in Armstrong 1, behind tab 26 of bundle 3, as you recall, that evidence is referred to at paragraph 25 of the judgment, and the paragraphs in question in Armstrong 1 are paragraph 16 Roman 3 and following. Again, I don't invite you to turn them up now. There are very significant sums overall that have been committed to this enterprise, and the structure is that it's set up so that not merely is a significant sum devoted, I'm summarising, but not merely is a significant sum devoted to try and ensure that the structures are put in place in an appropriate and proper and resourced manner at the outset, but there are then further sums that will be paid that are done by reference to individual cases that Rwanda handles, including additional funding for 5 years for individuals who are in fact granted refugee status by Rwanda. And my submission is you don't need the detail of the sensitive note verbal on funding to know the precise amounts per case. It is evident from Armstrong 1 that there is such funding, and you have a basic description of what it looks like, namely monies already committed to support infrastructure, plus going forward individual case monies, which increase to cover a period of 5 years, as it were, post the grant of refugee status, if that's the outcome of the process.
These sums aren't, if I've understood it correctly, an incentive to Rwanda because they're paid to the refugee, but they're paid for the support of the refugee. So Rwanda gets no benefit from them because they will simply deploy them. They have 100 refugees, they'll have 100 times X, and will spend it on those refugees.
Well, my lord, yes, but the money is still there, as it were, with money coming in for funding. It may amount to net zero, it may not. But the money has been put in and will continue to flow for as long as the refugees are there.
Yes, but there's particularly no profit element for Rwanda.
Well, I don't know the answer to that. They may or they may not.
Well, the way it's described by Mr.
Looks like it's designed to be covering cost rather than profit, of course.
Yes.
My lord, I take the point, but the money is there and the money is put in. If nothing else, even if it is net zero, as it were, to use that phrase in this context, it indicates the seriousness of the purpose with which this enterprise is being engaged.
I suppose in Little Roman 5, there's a reference to providing funding similar to that spent in the UK for the costs of processing each asylum claim. So that would appear to go to the Rwandan government.
I think it does. I don't know whether,
as well as providing.
I don't know precisely how it's been calculated and whether there are elements which operate to incentivise.
Yeah.
I mean, I don't.
But the evidence doesn't suggest, does it, or if it does, I haven't picked this up, that there is any understanding that sums of aid or sums not specifically related to support of the refugees.
No, there are no tie-ins of that kind.
No, that's what I understood. Thank you.
Well, can I just again? This is important, Sir James, and it may be that I may not have entirely understand. Little Romans 6 talks of the 120 million already paid, and then it goes on. The arrangement allows for further payments as the partnership develops, but these would be subject to the delivery of the assurances of the MOU. So I had understood that to be saying that the investment in economic transformation that is referred to as being the 120 million. The continued investment is conditional upon delivering the MOU.
My Lord, I think you're right to read it that way. I mean, the only reason I answered my Lord in the way I did was because my understanding is that most of that 120 million, despite the description of new economic transformation and integration fund, it's going to be used to support the infrastructure that these arrangements deliver. But there is some incentivisation there. Romans 6.
Well, has the money gone or not gone?
Has the money?
Has the 120 million gone or not gone to that?
It's gone. As I understand, it's gone. Yeah.
Yes, insofar as there is an element of incentivisation, it's the final
It's the final sentence that my Lord drew attention to. So there may be an element of incentivisation, but even if not, the fact of the matter is that this degree of investment, ongoing and upfront, emphasises and reinforces the seriousness of the importance that the system actually works and will be appreciated by Rwanda as such.
I mean, Sir James, what you're going to come on to deal with is whether there is any evidence that as at the date of these decisions, the infrastructure necessary to deal fairly with asylum claims was in place in the face of the UNHCR's evidence. And it might be that the money was there, paid, to spend on creating that infrastructure. But what if, when the decision was taken, the evidence was that no such infrastructure had yet been created?
Well, my Lord, I mean, I don't want to jump too far ahead, but that, as I understand it, is not the UNHCR's evidence.
Right. Okay.
The UNHCR's evidence is you can't trust them because of all these things, and the thing has structural faults. You need to go to paragraph 6 and 7 of the summary document called references that Mr. McCulloch gave you yesterday, which I will come and address in terms. Their case is not, there is no structure there that will cope with these things. Their contention is that there are flaws with that structure, rather than it not being present. And of course that, to some extent, my Lord's point also shades into the idea of capacity.
Slightly the same point.
And control of flow, exactly. So, I mean, at the moment we're talking about, and we are facing, as became evident when in exchange with my Lord, the Lord Chief Justice, a pretty extreme case that says it's not safe for anyone. It's a single case problem that is the assertion against us. But I'll come in due course when I deal with capacity to the ways in which the MOU is specifically designed to control the flow, so as to acknowledge that it may need to build up slow, as it were, and then increase as the systems are tested and work or don't. But the practical incentives, as I say, and I said earlier, don't just include the financial. They include the working relationship between, a diplomatic relationship between Rwanda and the United Kingdom, the seriousness of the context and how much is at stake for all concerned. Everyone knows about the seriousness of the issues and the reputation and political impacts if these arrangements that do not work satisfactorily. and indeed something of that point was made by the Court of Appeal at the interim relief stage, where there was a concern expressed by the claimants that this was an MOU and not a formal treaty, and therefore not enforceable as a matter of international law. And what the Court of Appeal said at paragraph 95 of their interim relief judgment, bundle 30, which is the third supplementary authorities bundle, which we've already been in once, tab 24. So this is the next tab, as it were, in the second of the Supreme Court cases we looked at.
You need to give me a page number.
485.
In the third supplementary
The
bundle.
third supplementary bundle, which is numbered bundle 30, which it should be, I'm hoping, the Court of Appeal interim relief judgment. And I want paragraph 95, which I'm hoping is at page 485.
It is.
So you'll see there they say the MOU and the may not be legally enforceable, even as a matter of international law, but they're formal agreements between sovereign states. The UK will expect Rwanda to comply with them. Rwanda authorities will know that their conduct will be under scrutiny in the particular context of people who've been removed there by the UK pursuant to the arrangement between the two countries. And indeed, that's not an unfamiliar theme or thought. There were lots of arguments of a similar kind with similar reasoning deployed by the courts in the context of, amongst others, in the context of extradition. One thinks of all those death penalty cases where people were being extradited to America and an undertaking was given by the Americans not to subject them to the death penalty. And there are various judgments which make it essentially the same point. But that point by the Court of Appeal at the interim relief stage was evidently the view also of the Divisional Court in its judgment here. That was an important point. I'm going to come back to Othman and the United Kingdom, which you've also seen cited in the judgment, but this is also a point that's been made by the European Court of Human Rights itself. Just give you the reference at this stage. Othman, paragraph 201, which is in the core authorities bundles, number 21, tab 66, and paragraph 201 is at page 2686, same point. That's what I wanted to say under the topic of assurances. The second of my 7 topics on this broad issue is a submission that the Divisional Court did not err in principle in their approach to either Suring or Othman. This is in effect ground 3 in the list of grounds that has been collated in the document that Underhill asked for. Ground 3, it's dealt with in our Court of Appeal skeleton, paragraphs 24 to 37. And I wanted just to make some brief submissions on the approach of the Divisional Court in principle. The first submission I make under this head is that it will be a very surprising error indeed if the error which is asserted, which is effectively to apply, the error asserted is effectively that the Divisional Court applied rationality rather than determining substantial grounds for real risk of ill treatment for themselves. A very surprising error if made by these experienced judges and in circumstances in which there was no dispute about the approach in principle under Article 3 and the question of real risk being one for the court. My submission is that the Divisional Court did not fall into that error and did not apply a rationality review when assessing the Article 3 issues. It considered, on the contrary, for itself whether there were reasonable grounds for believing that there would be a real risk of Article 3 ill treatment if there was removal to Rwanda. It analysed the evidence and the material for itself. It focused for obvious reasons, because it was centrally interested in the question whether or not the assurances in the MOU and the MVs would be met. It focused centrally on Othman, and it reached its own conclusion, as it pointed out in its consequential judgment. It might perhaps be thought that it was an even more surprising error, even if you leave out the points I've just made, given the structure of the judgment. It appears to be accepted that they applied, by the other side, that they applied the correct Article 3 approach, determining the issues for themselves, at paragraphs 74 to 77 of the judgment. Under the heading Conditions in Rwanda Generally. But it's then suggested that, as it were sub silentio, they then adopted a different approach at an earlier stage of the judgment, when considering, for example, the assurances that have been given. That's a very difficult and surprising analysis, if correct. It also needs to be borne in mind that the appellants also sought alongside, might be thought rather irrelevantly, but also sought alongside the Article 3 challenge to mount a rationality challenge, a substantive rationality challenge to the same set of issues. We submit that the correct position, when the judgment is read properly, fairly, and as a whole in this section, is that the Divisional Court analysed correctly and then applied the specific European Court of Human Rights Authority on which they place central reliance, namely Othman. That was the case they cited in paragraph 63 of the judgment, and that's the leading authority on this set of issues. But just to focus briefly on Othman for a moment, you'll be very familiar with it, but the European Court, as you will recall, in Othman, bundle 21, tab 66 if you want it before you, but they concluded that the deportation of Abu Qatada to Jordan would not violate Article 3 in the light of assurances given by the Jordanian government that he would be treated in accordance with Article 3 standards if he were to be removed there. And they did so, that's the European Court did so, I reached that conclusion, despite a finding that the torture of detainees, was generally widespread and routine, that's their wording, in Jordan. And in coming to that conclusion, against that very fraught backdrop, the European Court made clear that it will only be in, as they put it, rare cases that the general situation in a country means that no weight should be given to assurances seriously given. See paragraph 188, cited in the judgment of the Divisional Court at paragraph 63. And that is important in its own right as a principled approach. It indicates that the past may be of interest, but what really matters is the analysis of the present and the future in the light of the assurances that have been given.
It's not a question of no weight, is it? It's a question of how much weight.
That's true. That's true. But the point is nevertheless a good one. It's the focus which the facts of that case starkly illustrate. So the European Court's approach was, as my Lord the Master of the Rolls points out, to then judge the true weight that can be given to the assurances and whether or not they can be relied upon. They developed, as it were, a taxonomy. They developed a series of factors to which regard should be had, as one sees from the quoted paragraphs from Othman in the Divisional Court's judgment. They assess the quality of the assurances given and whether they can be relied upon in the light of the receiving state's practices, with the non-exhaustive list of factors that are then given in paragraph 189. So rather than inviting you to turn Othman up, you will see those paragraphs quoted in paragraph 63 of the Divisional Court's judgment, if that's more convenient and you have that to hand loose, as it were. it's important to bear in mind, not merely as a context for Othman, the point I've just made, which was a finding that there had been widespread and routine torture of detainees in Jordan, but also to note that there were concerns about the assurances based principally on a context in which the person concerned was considered to be a potential risk to that state. And you will be aware that that's quite often the context in which assurances are called into question, because the state can be assumed, as it were, to have an animus against the individual who is returned or removed to that state, often but not exclusively, because they are considered to have been involved in terrorism. So to put it very bluntly, the foreign state has, if that is the context, which it isn't here, a pretty strong incentive or an incentive to misbehave.
But the factors in that case, because of the particular circumstances of it, would not necessarily be the same factors as in a case of this kind, where you're looking at a third country to send a range of asylum seekers, where if you look down that list of factors, the one that is particularly relevant to us perhaps is the number 9, where there's an effective system of protection against torture in the receiving state. But here, one would have to look, would one, at the mechanisms in place for dealing fairly with asylum seekers?
Yes, one would. I mean, I make you will appreciate it. I mean, I fully accept that, my Lord's putting to me, as it were, as an incentive to focus on here. But you'll appreciate why I draw the distinctions that I do between the sort of context that often involved and the sort of context that you're dealing with here.
Right, but you would accept that you have to actually look at the assurances in the context of the situation on the ground.
I do accept that. And that is the reason I'm going through the points and will go through the points further when I come to the detail of the system on the ground. But I draw that initial distinction, a positive distinction in my submission, as it were, in my favour. Here you've got a system where, even though of course you're looking at the systems on the ground to see if those deliver, you don't have the sort of fraught context and practical disincentive from complying with assurances that might be created if there was to be animus against the individual being removed. That's the narrow and perhaps lesser point that I make, but I fully accept the point my Lord puts to me.
Well, one has to remember that these are not a statutory lexicon.
They are.
And, sometimes one sees in decisions a tendency to treat them as such and to go through each of them individually. My Lord has referred to number 9. I wonder really whether number 4, by analogy, maybe what in due course you'll be coming on to. So if the assurances have been issued by the central government of the receiving state, whether local authorities can be expected to abide by them. So essentially that's getting at the point. It's all very well for the central government sitting in the capital to give assurances.
If they're going to be in a small
are they going to be deliverable, if I put it in different language? And that essentially seems to me to be the point that the UNHCR in particular is arguing, that whatever the central government in Rwanda say, with good faith, the indications are that various parts of the system simply won't deliver it. And that, in a nutshell, I think, is the case that's being advanced against you.
My Lord, it is, and I'll come to the detail in due course, but the factors here we submit point strongly, and there was no error in the Divisional Court's analysis here, they point strongly towards those assurances in fact being honoured in practice. I mean, they analysed it over some paragraphs, as you know, between 62 and 71, particularly in the Divisional Court's judgment. I've been through the incentives on Rwanda to ensure compliance. I'm not sure we're quite in the situation where the individual might be sent off to some local prison, as it were, outside the maw of the central government machine. As it were, this is going to be run as a central government operation, is the evidence. But there's every incentive, reputational and financial, to not merely comply, but to ensure compliance. The detail of the arrangements and the assurances has been disclosed to the court with sufficient details given, and the assurances as they exist are specific and detailed as to the treatment which is expected and as to the processes which both governments envisage will be delivered under that. So you have, for example, the 3-month period of determination that's anticipated it will take to deal with these claims. You've got all the detail in the reception NV setting out detailed assurances regarding the provision of adequate accommodation, of food, of essential items, of free medical assistance, of education, free language training, access to interpreters, all of that. Professional development training, paragraph 13 of the reception NV. So that NV, leaving aside the asylum process one, itself is useful and important as ensuring that the conditions will be appropriate on return. See Bundle 3, tab 15 for the reception NV, and of course I'll come to the detail of the asylum process NV in due course. But that also is specific and detailed as to the processes that can be expected. And there is also, or there was also evidence before the Divisional Court about those processes being underpinned by arrangements on the ground. Mr. Williams, for example, gave evidence that he'd visited the initial accommodation, he provides detailed descriptions of it, and Mr. Krellin also gives evidence to the same effect. Their statements are behind tabs 29 and 31 in Bundle 3, and the relevant paragraphs perhaps for the reception NV purpose of Mr. Williams are 18 to 25 and 49, and in Mr. Krellin's paragraph 27.
That's not really where the true pinch is it? We haven't really had a challenge to that part.
Well, no, my lord, but that's true. But it's all part of the process, as it were. They're going to be put in proper accommodation. All of this is to be viewed together, and it is an important part of it. Frankly, if the reception MV did not exist, we can well expect challenges on the basis that the Refugee Convention was not being respected because there weren't sufficient assurances that they would be given all those things. But of course, my lord is right that the asylum NV is really where the true heart of this lies, and to that I will come. On the specific criticisms that are made of the Divisional Court's conclusions on this part of it, in other words, the erring of principle on Serring and Othman, which is the point we're still on, we've dealt with those in our skeleton for the Court of Appeal at paragraphs 41 to 47.
Which paragraphs?
41 to 47 of the Court of Appeal skeleton. But the first and second of them I've really dealt with. The submission is that the Divisional Court undertook the analysis for itself, and the judgment fairly read indicates that. The core of this point appeared to be an attack on the paragraphs dealing with Mr. Mustard's evidence, including in particular paragraph 66 of the Divisional Court's judgment. But my submission in response to that is that nothing that is there said about the respect to be accorded to the considered view of the Foreign Office, to which one would add, and indeed of the Home Office, nothing there is inconsistent with the idea that the court was doing a proper Article 3 job for itself. And the reason I say that is because it is entirely legitimate, in principle, as part of the court conducting that exercise for itself, to conclude that the Secretary of State was, as they put it, entitled to rely on the assurances, and to give that factor real weight, as the court did in both paragraph 66 and in 71. There's nothing inconsistent between applying that approach according respect in our domestic language or margin in the Strasbourg language to the expert and experienced view of the government on matters calling for a predictive judgment. Nothing inconsistent between applying that approach and nevertheless doing so in a convention context where they're considering issues for themselves. One thinks particularly about, I'm not sure it's in the bundle, one thinks, for example, about the Lord Carlisle case, which contained the famous description by Lord Sumption of how you go about approaching respect for those judgments in an Article 10 context there. But there's nothing inconsistent between according that respect and nevertheless doing the convention analysis for itself.
Could I just ask you, when they start on adequacy of the asylum system, which is obviously very important as you've accepted, they say next we consider, paragraph 62, whether the Home Secretary was entitled to conclude there were sufficient guarantees to ensure they would be properly determined. Is that the right question?
My Lord, my respectful submission is that it is the right question. There's no magic, as it were, in the idea that they were entitled so to conclude, particularly when one has regard to the core of the analysis of the court. The core of the analysis of the court was to say we start with the MOU and we start with the MVs. Ex facie, those documents and those assurances, if implemented, will be sufficient to deal, and indeed were designed with an eye to at least dealing with the concerns that have been raised inter alia by the UNHCR. So their analysis was to say that's our central focus, and the central question is therefore whether or not Rwanda will be meeting those commitments.
That's not what he says.
It is what it says when read fairly, because you have to read on from 62 to include 66. One has to see what the analysis was. I'll come back to this, but it's in large part the explanation for why they don't go through and conduct a trial, as it were, of every concern raised by the UNHCR. Because
by itself, you accept 62 is not quite right, unless you read fairly on. Construe it.
Well, one's got to.
I mean, is what I'm asking
yes.
is, I thought it was accepted that the test the court should be applying was to decide for itself whether there were substantial grounds for thinking there was a real risk that there would be breaches of Article 3.
Yes, that is accepted.
Yeah.
And there was no dispute about that below.
Yeah. But that, I mean, all I'm...
It's a slightly odd phraseology, but my explanation from that is read the rest of 62 and read the rest of what follows in this section of the judgment, including the bit where they accepted they were doing that exercise in 71 to 74. But in particular, you need to focus on the approach that they took to the question whether those assurances would be honoured, where they placed very significant reliance on the assessment and experienced assessment by the government that they would comply with the ex facie satisfactory assurances. And the submission I'm making now is that there's nothing inconsistent about asking that, as it were, entitled to question. Using the language of entitled to simply reflects respect or margin.
So my Lord's point might going to be encapsulated in this way, that it might have been better had it started, next we consider whether the Home Secretary was right to conclude, rather than entitled to conclude.
Well, my Lord, maybe it might have been better to do it that way, but
that would be the correct test, wouldn't it?
Yes, but my submission is.
So read as a whole, it's there.
Right.
Yes. But the simple submission made against you is that the court in one or two places has used the language of
entitled to
judicial review.
Yes, it
rather
has.
than
it has, and I've made the submission that that's no doubt in part because there was a rationality thing being run alongside in relation to exactly the same factors, but also, and perhaps more significantly, because the core of their analysis is to look at the MOU and the MVs and say, if those are done properly and according to their terms, that will be satisfactory and sufficient for Article 3 purposes. And on a convention analysis, where they write to reach that view, it's perfectly satisfactory to place respect on the judgment that is made by the Foreign Office and the Home Office. And that is, as it were, simply a reflection of the entitled to language. But you can see how they approach the matter by reading that section as a whole, including the, as it were, the codicil to paragraph 63 after the quote in offer.
And that you give the same response in relation, obviously, to the beginning of para 64 and to the slightly different language, but with the same flavour at the end of para 66.
Yes, and that's, which is squarely on how do we approach the government's judgment that they will abide by the assurances. And even asking, if you assume that the question at the beginning says, was the Home Secretary right? Or in our view, is it right that there is a real risk of grounds for there being a real risk? They would still be entitled to accord very considerable respect on a convention analysis by themselves to those judgment calls by the government.
And you say the same about the, again, it's a different language, but the same flavour, the end of para 68. Admissible approach in an error of law.
Yeah, I do. I say, I mean, it's a passage that has to be read in its entirety, recognising that within the convention analysis, it is proper to accord respect, and there's nothing to undermine. If there's nothing to undermine that judgment by the government, then the language of entitled to is a.
If you were wrong about this, Sir James, and the wrong test had been stated by the Divisional Court, presumably that means we have to do the exercise again.
Well, I suppose you would then have to consider whether the factors that were relied upon by the court and the substantive approach they took.
We have to determine
with satisfaction. I think you probably would get close to that, but in reliance upon the findings that they've made, the approach that they took, substantively, as it were. I come back to the point: it's a surprising error for them to have committed.
Yes.
Given the expertise and experience of those judges, given that there was no dispute, and given that everyone accepts that the right approach was in fact followed when they got to conditions in Rwanda generally in 71 to 74, and this is all part of a piece as a structure of the judgments. And given also the point I keep banging on about, which is that even within an approach that says we, the court, ask ourselves that question, and we are the ultimate arbiters of that, it is entirely appropriate to attach considerable respect to the judgments made by the Foreign Office as to whether or not the assurances would be met. And that is simply reflected in the language of entitled to.
I mean, it might be said they dealt with it in funny order, actually, but I mean, obviously a matter for them. But the conditions in Rwanda might come first, one might think.
They might, although I suspect the reason they did it this way was because they appreciated, as my lord has already put to me once this morning, that the central focus of all of this was on the structures and processes in Rwanda rather than on the more general conditions or the state of Rwandan law. That's really where the battleground lay. That's the UNHCR stuff.
Anyway, that was only your second point, so.
Yes, that was, as it were, traversing back to whether or not they'd erred in principle.
Yeah.
And the first and the second of the criticisms that we deal with in our skeleton before you. I don't need to repeat, I suspect, the answers to the third and fourth of the criticisms. We've dealt with those in our skeleton at 43, paras 43 to 46. I suppose the only other final point to make in relation to these assurances and the approach in principle is to note that this is in effect a preemptive challenge. In effect, it is in fact a preemptive challenge.
Sorry, yes, sorry, I see this is still under your head too.
Yeah, this is a preemptive challenge, and so of course, one has some regard to the past and so on, but you'll be fed up with me saying, by the end of the submissions, if not already, that we've got a new set of arrangements and assurances here that are in place, and they are, given the nature of this challenge, to be given full force. It's a high hurdle to suggest in advance of their operation that they won't work. That also is a point of some significance to the approach.
Well, I mean, you will come to it, Sir James, but the independence of the judiciary is something that it's quite hard to change if there were question marks. So it's all very well saying we've got assurances that there'll be a court remedy and lawyers at that stage, but that is dependent upon whether the independence of the judiciary exists in the country.
I'm going to come to that. You won't be surprised to hear me here.
Yeah, I don't
So,
know.
it requires a bit of a close analysis in the first instance, at least of the extradition case that Lord Justice Owen and Mr. Justice Foskett promulgated, and what it was actually deciding, and what the context of that case was, and what truly the court found there.
All 500 paragraphs.
All 500. I know how keen you are on long judgments to assist the
Oh, you do know that?
public understand the issues and their resolution. No doubt they were very complicated issues that arose in
Share that enthusiasm with my lord.
Just one small point on this aspect. Is there any law on the correct approach where a court, when asked for permission to appeal on a particular point, says, "Oh, well,
we didn't do
that's
that.
not quite what we meant." It's a situation one occasionally comes across, and I don't know whether anyone has ever said anything about
My lord, I'm not aware of any directly. I don't know if Mr. Hussain correctly identified the Lord Hoffman idea that says once you've handed it down, it's no longer your property. We don't care what you say about it. And I suspect
Yes, it's a slightly absolutist position.
it is a slightly absolutist decision. So there may be some shading on it, but I suspect that the correct position is somewhere a little south of that, but not very much south of that. You can take it into account for what it's worth. If it's entirely clear that they actually did something completely different, well, that may be one thing. But if it's more doubtful than that, it may carry some significance that they didn't believe they were doing that, particularly when you have judgments, or a judgment of this kind structured as it was, where it's accepted, at least in the latter part of it, they were applying exactly the right approach, despite some of the oddities of language which we've been discussing.
So that's
my second.
two. I think you alerted us to quite a few more, so we must.
Yeah,
we must move on.
Three is monitoring.
Yes.
Sorry? Yes.
My lords, I'm really sorry. Could I just ask for a pause for a minute?
Yes, of course. Are you happy for Sir James to carry on?
I'd rather
You've got-
just on this one occasion. I wrote to the court. I don't know.
Yes, no, I do understand it, but you've got about seven
So be
people
it.
with you.
So be it. So be it.
So I think by all
If you prefer he
means,
carried on.
we're very short of time. So
No,
we're,
my
of
lord,
course,
apologies.
Mr. Hussain, if you would need to
Apologies.
leave court for a moment, please do. Yes.
Well, I don't want to inconvenience my learned friend.
No. Well, I mean,
I'm very happy for Sir James.
because otherwise we all have to rise,
I
don't we?
completely understand. I'm so sorry to even raise this.
No. But we understand the point, but I think we need to keep going. Yes.
I don't think there'll be much, shall I say, on monitoring which will come as any great surprise. Definitely come.
Yes.
So far as monitoring is concerned, the arrangements will be, we submit, independently monitored, as Rwanda is well aware, part of the monitoring arrangements themselves. And paragraph 65 of the judgment properly placed reliance on those structures. And they provide, as it were, yet another practical bulwark against things going awry. There are specific arrangements put in place to monitor compliance, precisely compliance, with the arrangements that have been agreed. So there is the joint committee, judgment of the Divisional Court, paragraph 22. The joint committee's terms of reference are at bundle 4, tab 69, page 1350. may still be described as draft, but they're exactly the same form and final, so there's nothing there. And under those terms of reference, the Joint Committee are responsible for ensuring that the terms of reference for the monitoring committee and the process for ensuring that the monitoring committee work properly, and that the monitoring committee has, as it's put in those terms of reference, i.e. the Joint Committee's terms of reference, unfettered access for the purpose of completing their assessments and reports. So the Joint Committee, as it were, sits on the top, and the monitoring committee does the assurance processes below and reports. The monitoring committee is provided for in the MOU at paragraph 15, as the judgment of the Divisional Court noted at paragraph 23. And again, my submission is that that process, or those processes, were correctly relied upon by the Divisional Court at paragraph 65. The terms of reference for the monitoring committee are set out at bundle 4, tab 82, page 1597. And I don't invite you to turn them up now, as they say all the things you'd expect them to say, but they are designed to ensure that there is full access for the monitoring committee on all aspects of these arrangements in their practical operation. And the monitoring committee are required to produce a formal written report to the Joint Committee every quarter for the first 2 years. And those terms of reference are themselves subject to review every year by the Joint Committee. The setup of the monitoring committee is dealt with in the evidence of Mr. Armstrong, again bundle 3, tab 26. See, for this purpose, paragraph 73 of Mr. Armstrong and following, including pointing out that they are ensured access guaranteed to all parts of the process in the MOU. And you've got a fifth statement from Mr. Armstrong, bundle 3, tab 34, page 1117, giving the composition of the monitoring committee. And if you wanted the composition of the monitoring committee in the raw, see bundle 4, tab 81, page 1592. So those matters between them, that process provides the United Kingdom government, and indeed the Rwandan government, with the ability to monitor those practical arrangements in practice and on the ground. And there are people embedded in the High Commission in Rwanda from the United Kingdom who are involved in that process, unsurprisingly. In addition to that, there are Home Office officials currently based in Rwanda, and they can see the arrangements that have already been made, and they will be well placed to provide, as it were, a direct line back to the United Kingdom about Rwanda's compliance with the assurances. And the degree of access that those Home Office officials have been given, and the closeness of the cooperation between Rwanda and the design and setting up of the structures and everything else, is dealt with by Mr. Williams in his statement, bundle 3, tab 29, in Mr. Krellin's first and second statements, bundle 3, tabs 31 and 33, just for the flavour of it, as it were, but also dealt with in the MOU. Can I just take you to one thing, which is back to the MOU, I'm afraid. Bundle 3, tab 13, page 686. And I want paragraph 13 on 686, if you could just cast an eye down that. So you'll see that there is concern, no doubt driven in large part by the United Kingdom government, which Rwanda is entirely content with. There are processes of a real practical kind, both in relation to the Joint Committee and the Monitoring Committee, and indeed access that UK officials will be afforded on the ground. The suggestion Mr. Hussain made in his oral submissions to this court was that, well, you can't place much reliance on the monitoring because he said they're not binding or enforceable. To which the answer is that these are interstate arrangements, specifically designed, having been put into the public domain in that way, specifically designed to police the detailed and specific arrangements with all of the incentives I've already dealt with. You don't need some legal enforcement mechanism. Indeed, that would probably be entirely unsuitable for these sort of monitoring arrangements to be practically effective. These are designed to operate at the interstate level with the independence of the committees set out below, providing additional assurance. And I should say that although, of course, the United Kingdom government is very well alive to the extremely valuable work that UNHCR will no doubt continue to do on the ground, there is no requirement for the UNHCR, as it were, to have permanent access to all our SDC decisions or all parts of the process at all stages. They will no doubt shout loudly, as loud as they have done in this litigation, if problems of a practical kind arise during the operation of these arrangements. We respectfully submit that that's a positive so far as general monitoring and oversight is concerned. My fourth topic turns to the UNHCR directly, at least in the first instance in relation to the approach in principle adopted by the Divisional Court to the UNHCR's evidence. And my submission is that the Divisional Court made no error of principle in their approach to the UNHCR views. We've dealt with that in our Court of Appeal skeleton at paragraphs 7 and 27 to 32. It is clear, I respectfully submit, and doesn't really appear to be seriously controversied, that the Secretary of State is entitled and indeed bound to make her own assessment about the deliverability of those assurances, and thus, if she considers it appropriate, to differ from the views of a UNHCR official. The UNHCR does not, as the courts have stressed, have judicial or quasi-judicial status. See Lord Justice Elias in HF, Iraq, paragraphs 43 to 44. That's in the first supplemental authorities bundle, number 23, tab 21.
Sorry, I'm so sorry.
I'm so sorry. HF Iraq, 43 to 44 are the paragraph numbers. The bundle is 23. The tab is 21, and the page number for those paragraphs is 691. And you also have in that same bundle, sorry, in the next bundle, bundle 24, at tab 37, you also have AS Afghanistan, again a Court of Appeal decision, I think from memory, Lord Justice Davis. The relevant paragraphs there are 17 to 23, which I hope is 1395 in the page numbering. So bundle 24, tab 37, page 1395, paragraphs 17 to 23. And I respectfully submit that those views are faithfully reflected in the approach that the Divisional Court took as recorded in paragraph 71 of their judgment. I make it absolutely clear that no one on this side of the court suggests that the views expressed by UNHCR are not entitled to serious respect and consideration. But everything, as I think we're all agreed, depends on the context and the facts. And
It was said, Sir James, I think by the UNHCR, the submissions themselves that this was particularly the case here, where they had special expertise in the subjects about which they were talking, and that therefore, whilst it was correct to say that the evidence had only normal status as evidence, where the UNHCR spoke about things it had a real expertise about, with 300 people on the ground or whatever it was entitled to significant respect.
Well, my lord, I entirely accept that respect and consideration needs to be given, and was in fact given, to their views, both by the Home Secretary, I'll come to that in a moment, but also by the court. But I do make perhaps 4 short points in answer to that assertion, and it may just go to degrees of weight, and so we may be dancing on the head of a philosophical pin, but 4 short points anyway. They are not expert and experienced in relation to these arrangements, or the more general issues as to whether or not, in a context such as this, with all of the build-in, all of the seriousness, all of the incentives, one state can be confident that another state will conform to the arrangements seriously undertaken. Those are matters on which the expertise and experience, and indeed the constitutional proprieties, rest with the government. Second point, these are new and bespoke arrangements. So much of what may or may not have happened or gone before in relation to earlier conduct or earlier arrangements or systems within Rwanda are at best of peripheral and possibly of very limited assistance. There are specific points I'll come to in relation to some of the cases relied upon, but I make that as a general second point. We are not, third point, dealing here with the examination of an individual case or with careful guidelines of the kind considered in HF. We're dealing instead with a mishmash, as it were, of historic cases or incidents, some at least of which are controversial with the relevant government concerned. But more importantly, we are dealing with a predictive judgment about new arrangements now in place. And the fourth point is that there has been the most extensive consideration, I'll come to this in detail in the context of Ilias, but there has been the most extensive consideration given to these issues, including the concerns raised by UNHCR, when designing these arrangements. And the UK, we submit, is properly the primary judgment maker in that sort of context. And I do submit, therefore, that the points that the Divisional Court made at paragraphs 69 to 71 of their judgment were all well made, including the slightly raised eyebrow as to the apparently much more extreme position that came to be taken orally by them at the hearing. Paragraph 70 of that judgment was also correct for good measure, although perhaps this is a point of less significance because the UNHCR concerns were considered on their merits by the Divisional Court in any event. But the Divisional Court did properly note that a July 2020 UNHCR report did make a statement about Rwanda, reflecting and recording a view of UNHCR that there was in Rwanda, quote, a general respect for the principle of non-refoulement. And I submit that the Divisional Court was right to rely upon that.
Now, we haven't actually, in the course of this hearing so far, turned that document up, and although I think we've all looked at it, could you just remind me of the reference?
Well, I can give you the reference. The reason I haven't turned it up, and I'm not inviting you to turn it up now, I'll give you the reference in a second, but because below there was some suggestion that that had been misread, and the Home Secretary had misunderstood the nature of that sentence and what it was saying, properly read in context, and that is no longer an issue in this appeal, so you can take it as properly understood at least. The reference for your note is Bundle 5, tab 95.
Sorry, my lord, just to correct Assistant Sir James, that's not our position. She misread that passage. If you turn it up,
Sir James, shall we just look at it quickly so that we can
Bundle 5,
Yes.
tab 95, page 1669.
1095. So,
Yes, two bits in it perhaps. 1669, penultimate paragraph, last full paragraph on the page. Second sentence.
yes, and I suppose the point will be it's referring to influxes from neighbouring countries, and Mr. Hussein is nodding. So
Yes, well that's the point made, and the submission in answer to that was there was nothing in the sentence or its context limiting it to that influx from neighbours. The heading is not limited to a particular subset of refugee status determination.
But the whole context, when I read this at first, the whole context is Rwanda's position ordering effectively DRC and other conflict countries, not really concerned with the types of terms which were concerned here.
Well, my lord, my submission is that it's a generalised statement. Of course, it sits in that context, but it isn't limited in that way.
Can I ask Sir James to please read 1671, middle of the page, issue 2.
Issue 2. Access to the system, yes.
Yeah, of course.
Please read that.
Has the court got that paragraph? And the one below, the 2014 law relating to refugees is fully compliant with international standards and sufficiently details the RSD processes.
It's the I was invited. I read passages he asked me to read. I was asking Sir James to read the first paragraph with the concluding sentence that refugees who arrive outside the time frame for prima facie recognition need to be recognised individually and face obstacles, etc.
Well, I was rather hoping that was the paragraph the court was going to read, as invited, but there we are.
Yes,
You've
but we understand the nature of the disagreement.
Yeah. I'm grateful.
Which was rather why I thought it was useful to look at it.
Well, as I fully understand, the argument in this court is fined down so that it's now an argument about the weight, the precise degree of weight to be accorded to UNHCR views. My submission is that the Divisional Court were entitled to reach the views they did on the overall UNHCR position in judgment paragraph 70. And more, or as fundamentally, the Divisional Court's focus was on the brave new world, that's the right way of describing it, of the assurances with all of the incentives I've gone through. And the question they regarded as central was whether or not Rwanda would comply with those, rather than the focus of UNHCR, which unsurprisingly was on past incidents of concern. And the reason that is significant to the structure of the judgment I've touched on already, if the judgment was properly made by the Secretary of State and reviewed, as it were, by the Divisional Court, not to go back over the Article 3 debate, that they would comply with those arrangements, and that would go a very, very long way indeed, particularly in relation to a predictive judgment, to address the key concerns that had arisen in the past. And that is the remit of the Secretary of State, with the Secretary of State carrying the requisite expertise and experience. So far as the Secretary of State was concerned, the Secretary of State was well alive to the concerns, and is well alive to the concerns raised by UNHCR, aware of them when designing and setting the content of the assurances that were given by Rwanda, reflected in the MOU and the MDs. Also properly putting those concerns to Rwanda and asking for responses under the specific provisions of the MOU that I took you to earlier on, that enabled that to be done and created a seriousness of context for that process. And the overarching picture is that, at least as to some of those issues, and some significant numbers of those issues, there was a genuine question about whether or not they were incidents of concern, and if so, how they arose, and what the true position had been historically on the facts. But there's nothing wrong, we submit, with the Secretary of State taking the view that the assurances seriously given and detailed were the key. And there were, and I'll come to the specific reasons in due course, also reasons for concluding that even if there were issues of the kind raised by the UNHCR, they would be highly unlikely to arise under the new arrangements.
Formulated that as terms of there's nothing wrong with the Secretary of State taking the view.
Because I'm focusing for the moment on the Secretary of State, I'm going to come to the Divisional Court in a second. Because this, as it were, feeds into the margined judgment that is referred to in the muster statement, reflecting the views of government. There was some suggestion in the UNHCR's submissions that it was all intensely problematic because they weren't involved in the negotiations with Rwanda about the MOU and the note verbal. But that point only goes so far. They were not involved in those specific discussions and negotiations, entirely unsurprisingly, because this is a state-to-state diplomatic agreement and arrangement, or set of arrangements. They were, however, engaged in relation to the asylum system in Rwanda for the purposes of the CPIN. And again, I don't want to spend too long on this point, but the Home Office conducted a detailed interview with the UNHCR. It's referred to in Mr. Stairs' statement at paragraph 21, bundle 3, tab 28, page 1065. And annex 8 to the interview CPIN, perhaps it is worth just turning that up so you can see what it looks like. Bundle 3, tab 20. Are the interview notes.
You've got a page number.
Yes, I'm so sorry. Let me just get note 940. So behind tab 20 within bundle 3, page 940 in the electronic. And you'll see that Annex 8 is a meeting with the UNHCR on the 21st of March 2022. And then a whole bunch of questions. And that's what follows is in effect an 11-page note of that interview and the detail of the matters discussed. And of course, that interview then raises points which are then covered and feed into not merely the nature of the arrangements, but also the country information, CPIN. That they fed into the negotiations and the final asylum process note verbal is confirmed by the Armstrong evidence, Armstrong 1, paragraph 28, bundle 3, tab 26, page 1024.
Sorry, can you give the reference again?
Bundle 3, tab 26, page 1024, para 28 of Armstrong. And he there gives, I don't invite you to turn it up now, but he there gives, as a particular example of how stakeholders impacted on the assurances sought from these sorts of interviews and the information gathering process impacted on the note verbal, he gives as a specific example the worry that some stakeholders have raised about the government of Rwanda not always providing a reasoned asylum decision. And you'll recall that Mr. Minsky took you to what might be described as a crisply reasoned past decision of one of the relevant committees. But the point for present purposes is that that sort of engagement led precisely to a specific provision, as Mr. Armstrong states in paragraph 28, in the note verbal dealing with the asylum processes at paragraph 4.8 of that note verbal. Relocated individuals will be notified in writing of the decision to take on their asylum claim and so on, with reasons. That's in tab 14 of bundle 3. There's then criticism, I said I was dealing with the Home Secretary, then the Divisional Court in relation to the way in which that was done on the UNHCR concerns. And the short answer to that is that they didn't need to go through all of the incidents. There were submissions about many of them. I'll come back to some of them in due course, for the reasons I've given. The approach of the Divisional Court was at heart, here are new arrangements. They're new and bespoke, they are detailed, they're ex facie satisfactory and were designed to be such in the light of the concerns, the core concerns identified by UNHCR. And the judgment is whether or not they can and should be expected to operate according to their terms. So the criticism of historic or different Rwandan systems and structures is of limited, if any, real use, even if you leave out of account the points I'm going to come to about specific reasons for some of those instances of concern, for assuming or for concluding that that sort of concern simply wouldn't arise at all under the arrangements as set out. But that was the approach of the Divisional Court.
Can I ask about paragraph 28 of Mr. Armstrong?
Yes.
He says there, it was noted that from the detailed assessment of the asylum process and the comments of stakeholders, that individuals were not always given reasons, written decision, and we got assurances that they would be. How do we balance that, or how did the Divisional Court balance that against the UNHCR evidence of what reasons were actually being given on the ground at the beginning of 2022 to asylum seekers? And we were shown yesterday, you remember, an example of a notification which gave no reasons effectively. What do you say about that?
My Lord, I say that there is a new arrangement specifically requiring reasons, which will be monitored.
It hasn't happened yet, but it will.
It hasn't happened yet, but it will. I mean, I don't know whether that's the single example that you've seen was representative of all decisions that were made previously under the system. But there was obviously a concern that had been raised, so a specific provision is put in the NV. So if you get an unreasoned decision next time round, I'll have some sympathy with the view that that was an unreasoned decision, it was simply a statement of outcome, then that can be expected not merely to be met under the new arrangements, because there's now a specific provision in the asylum process NV, but also you have the practical incentives and the practical oversight that is provided and built into those documents. It's perhaps a pretty good example of the limited relevance, if any, of past practices and processes.
But we have no idea how the RSDC will set about giving reasons.
Well, we don't, because they haven't done it under these arrangements. No one has been processed. We are here. My Lord, there isn't. It would be quite a surprising thing to put in, to take a point rather than.
Well, I see that, but it points to one of the difficulties of the predictive exercise is that to move from a culture where you give a one-line reason saying your objections are not pertinent to something I think nobody's suggesting need be exactly like the kind of reasons that caseworkers in the Home Office give, but much more substantial reasons. How are people going to know how to do that?
how are decision makers to know?
How are the RSDC or the people who write their decisions, who write up their decisions, going to know how to reason such decisions? Answer, I suppose they're going to be trained.
Well, they're going to be trained in part, and the obligation is going to be clear.
It's my fault. You're going to come back, I think, perhaps to some aspects. We're still technically under the heading of refoulement, aren't we?
Well, we are, but I mean, to take the point directly, if there is a concern identified that in the past there haven't been sufficient reasons, and you're charged with the task of setting out in the note verbal the requirements of a system that would be adequate, then you produce the sort of provision that we seek. It'd be a very surprising thing to see in this sort of document, a kind of detailed set of guidance, and the obligation to give reasons will be clear. And if it turns out in practice if it turns out in practice that reasons are not being given, then you've got a clear failure to abide by the arrangements. That's, I respectfully submit, not a proper conclusion that anyone could draw. I'm not sure how much more would be necessary at this stage. That there will be training and there may need to be guidance on the ground as one goes forward. But it isn't a sine qua non to the solution to this problem. This shows the reaction to a problem identified and is sufficient, I respectfully submit. As far as the Divisional Court is concerned, as I say, I've gone through a couple of times now the way in which they appear to have approached the issues, and I submit that there isn't a need, and there wasn't a need for the Divisional Court to do the sort of thing that was repeatedly suggested they should have done, namely to as it were, conduct a trial of the past and historic issues, if that makes sense. I mean, you've got a series of concerns being raised by UNHCR, and the Memorandum of Understanding anticipated that those sorts of issues might arise, and in effect set up a requirement on the government of Rwanda to respond. And so the process that was envisaged by the Memorandum of Understanding was clearly, and for good reason, followed. You then have the government of Rwanda responses, and judgments have to be made accordingly. But if you take the view, as the Divisional Court evidently did, that this new set of arrangements, if complied with, would be sufficient, then it is simply not necessary for them to have decided one way or t'other whether an incident at Kigali Airport was good, bad, or indifferent. To take that as an example.
I mean, once you accept the test is substantial grounds for thinking there's a real risk, that has to be fed in, does it not, to the evaluation of the assurances alongside the evidence of what's happening now?
Well, yes, it does, of course. I entirely accept that in principle. But that is what's been done. You haven't got these arrangements. You haven't got any cases flowing through the system under these arrangements. So there necessarily has to be a degree of prediction. But those central features, those structural planks in that process are, as the evidence indicates, designed in significant part to seek to ensure that concerns that have arisen in the past, good, bad, or indifferent, right or wrong, and some of them are the subject of some discussion, to put it mildly, between the government of Rwanda and the UNHCR. The question for this purpose is whether or not the court, i.e. the Divisional Court, had to go through and say, well, yes, in relation to that, no, in relation to the other. But my submission is that there's no reason to do that. They were well aware of UNHCR's concerns. They set out what those concerns were and what the claimants sought to make of them in their judgment at paragraphs 53 to 58, and then considered some of them in the judgment that followed, but they did not engage in. And my submission is that there was no requirement for them to engage in a more detailed exercise of seeking to determine the correctness or otherwise of what in some considerable number of instances were competing views between government of Rwanda and UNHCR, as I say. one can't, as it were, dismiss the government of Rwanda riposte as the riposte of someone party free on the basis that they were well alive to the idea that the United Kingdom government might come knocking. And there was a specific provision in the MOU making particular provision for them to do so, and to do so in a serious context of litigation before these courts. Can I turn as the fifth topic, and it's linked, I'm afraid some of these topics are linked. I turn as the fifth topic to the concerns about the history of compliance with international obligation and assurances, the merits of those concerns. And I repeat the short, core and overarching answer already given. Even if, and to the extent that those concerns were or might be well-founded, there is a need to consider the future risks, as it were, in this context. And that can only be done and can sensibly be done on the basis of focus on the particular structures that are envisaged in the MOU and the asylum process MV in particular. And that's what the Divisional Court did. There were a number of cases referred to, and I'm going to try and pick up all of them, but just to group them under some topics, as it were, taking those topics or those incidents from the schedule, you'll recall the schedule to which you were taken, the UNHCR schedule, the claimant summary of it. And the first of the issues on which considerable attention has been devoted by my learned friends is the Israel-Rwanda arrangement. And my submissions in relation to that are that that was a different arrangement with a different state to which the United Kingdom was not privy, running between 2013, it appears, and around about 2018. The reputational and financial incentives appear at least to have been very different in the context of that arrangement. There appears to be, facts appear to be that Israel paid for the individual's journey to Rwanda and gave them a one-time payment of $3,500 without assisting beyond that point. Again, that's to be contrasted with the points on funding and the detail and care that sits across the MOU and the NVs in all its aspects, including the powerful practical incentives that Rwanda is under to comply with those arrangements. Very difficult to see that there's any significant point to be taken about the idea that we don't know, no one knows whether the assurances were or might have been different to the UK ones. And it seems entirely clear that the UK-Rwanda agreements and arrangements set up in the MOU and the NVs that you've seen were bespoke. That they were the product of discussion and negotiation between the governments in the light of the particular concerns that particularly the United Kingdom government might have to ensure that the structures were properly in place. And there's nothing remotely to suggest that the Israeli-Rwanda ones were anything remotely similar, as my learned friend Mr. Hussain almost accepted. Mr. McCulloch then produces, or seeks to produce, the version of the judgment of the Israeli Supreme Court that you saw and relies, I think, on paragraph 87. Again, there's limited information in that, but it looks as though there's if there were assurances, they were of an extremely general and high-level kind. And if one takes that judgment at face value as some indication what might have been in place between Israel and Rwanda, if anything.
Are you talking about the judgment that we were sent overnight?
Yes. Paragraph 87, I think, was the paragraph he floated yesterday and was drawing attention to in his email of yesterday. But at the very best, those are, if they have to be taken as the position, non-comparable in terms of their detail.
Is the point not that the detail is different, but if it were to be shown, and I'm not sure whether you accept it has been or not, but there were assurances given and they were not complied with?
Well, my lord, that is an aspect of the point. I've gone through, and I don't repeat all the points I've made about the bespoke nature and the detail of our arrangements and the practical incentives that exist in our context. So that is a legitimate point of comparison, I respectfully submit. I entirely take the point that if you've got clear evidence that Rwanda is as it were, a serial assurance breaker, then that might be relevant. But
well, that's an Ottoman point.
That's the Ottoman point, yeah.
Yes.
But again, one doesn't know. It's very difficult to make judgments about that, frankly. But there were plainly some incidents of concern, and I have no idea what the true facts were. I mean, in part, this is a point about whether or not there was. This is a point that sounds in Ilias about whether there was a need, as it were, for the government to seek to chase down those issues. What precisely was the nature of the assurances? Were they as detailed as ours? Here's a comparison. Did they or did they not breach assurances? Did Israel raise questions about whether or not they breached those assurances? And all of that. And my submission is there isn't a need to do that.
Well, you're going to come to Ilias.
I'm going to come to Ilias in due course. But my submission is that the Israel arrangement and what it shows and the incidents that were relied upon there is shortly answered by the fact that here we have our own bespoke arrangements. Not entirely sure how one would chase down the attempts to resolve all of the issues that would be needed to get to a place of making a judgment about whether they were truly comparable, and if they were truly comparable in any shape or form, whether those were in fact breaches of assurances or not. I can see all sorts of difficulties associated with that. There were then a number of instances, query precisely how many, but smaller number of instances of, as it were, refusal or refoulement from Kigali airport. And concerns that people might have been turned away at the border or turned away at the port of entry. And the key and short answer to that is that there is no real risk of the same thing happening with any of the relocated individuals under the UK-Rwanda arrangements. And indeed, just to give you a reference, which was much bruited about in the Divisional Court, the UNHCR themselves accepted that. Paragraph 28 of their observations before the High Court, see Bundle 2, tab 12, page 667. But the two key points are that the very purpose of the MOU and the NVs is to transfer individuals to Rwanda for the processing and determination of their asylum claims. And inherent in that process, and with specific provision made for it, there is an approval process. If you go back to the MOU, if you take up that document again, it's Bundle 3, tab 13, and you go to paragraph 3.2. Paragraph 3 is the one I referred to earlier, but at least worth casting an eye down. So this is the point I was going to about the flow, controlling the flow, but it's also relevant here because it indicates that there is an approval process to approve each and every transfer, with Rwanda having consented to that individual going to Rwanda for the purpose of having their asylum claim determined before anyone ever gets on a plane. Having done that, the idea that they're then going to be subjected to the sort of turning away at the border conduct, if that did indeed occur, then it's entirely improbable given that structure of that transfer. That's the first and core point. The second point is that, the subsidiary point perhaps, is that even if the government of Rwanda did refuse to accept an individual despite that process, the indications from the cases relied upon is that what happened was, this was the chain refoulement debate, they were sent back to the place from which they'd come. The chain refoulement problem was the problem that said, well, they haven't got a residence permit there or they may not have a residence permit there. So there's deep concern that they then be shipped back from that country, Dubai, wherever, or wherever it was that they went to a country where they feared persecution. But if that history tells you anything, even assuming you get to that point, which is improbable to the nth degree given the process set out in the MOU, the return there will be to the United Kingdom, if that's to be replicated, if that conduct is to be replicated. But my main point is there is no risk of that happening at all in the context of an arrangement between the states that requires the prior approval of Rwanda before a single individual is accepted. There was some concern, I can't remember whether that's part of the submissions that are still before this court or not, but there was some concern below, and I suspect it's at least included in the table, of non-African states from a country with which Rwanda has close diplomatic relations. There was some concern that they were taking refoulement decisions on the basis of international relations, I think is the way in which it was likely put. That's that point. But again, the short and complete answer to that, even on UNHCR's own evidence, is that as they confirmed to the Divisional Court specifically, none of the claimants come from the country in question. And you have that confirmed if necessary in the transcript that asks that specific question. So we do submit that those key elements, those key concerns about Rwanda's past conduct, principally focusing on the Israeli arrangements, which I've given answers to, and the turning away at the border, and then also the turning away because of international relations, all of which are said to create past problems and issues about refugee.
Are you going to deal, Sir James, with the allegations of refoulement in the sense of sending people across country to other states within Africa?
Is that
just the ones at the airport?
Transfers to Uganda in particular.
and that's the Burundian point, is it? I'm never sure which ones are.
I think the suggestion was that the body concerned, forgive me, I still haven't got all the acronyms firmly in my mind, the DGIE, is it, would, there's a history of them pushing people over the border into Uganda.
Yes, I think that's the Burundians, but in which case it's a very different context.
I thought it was wider, but I may have misunderstood. Others are nodding that I've got it right, and you may be mistaken on this occasion.
Okay, I think I'm going to come to that when I deal with DGIE.
Okay.
If not, I'll make a note to
Could you?
make sure I've got the right allegation. Again, my answer is going to be pretty similar, which is that here you've got a set of arrangements that, under which Rwanda agreed to determine the asylum claims and have agreed what happens afterwards, including, as it were, all the financial support that gets provided if asylum is in fact granted. So,
sorry, Sir James, I think you said on the point about decisions being taken on the basis of international relations with a particular country, you said it was accepted below that none of the applicants came from the country in question. Do you have a reference for that, or?
I think I've got a general reference to the transcript bundles. I might just
well, no, if it's not in the bundles we have, don't worry.
It is. It's in bundle 31, tab 5, page 31. Says my note, but I'll check.
Confirm it over now.
Tabs 5 and 6 of bundle 31. I'm told. Pages 31 and 35. I'll double check that. And you take that as accurate and that's corrected. Rwanda's capacity is the sixth subject. See in particular in our skeleton for this court paragraph 46 Roman 2 and footnote 60 giving references into the evidence if you need it. And for good measure, if you want it, I think slightly more detail on this in the Divisional Court skeleton from us. Paragraph 8.23 bracket 7. It's impossible to believe it had got down to that fineness, but there we are. And that's in bundle 2, tab 11, page 553. But on capacity, the case is an extreme one. The contention is that the Divisional Court was wrong not to have concluded that Rwanda was not safe for any single migrant. That's ultimately the case that's been mounted. My submission is that there was no error in the analysis of the Divisional Court. See, for present purposes, paragraph 65 of their judgment and 57 brackets 2 of their judgment. They acknowledged that the point was a predictive one and gave their answers.
Sorry, paragraph 6J.
65 and 57 2. I gave you...
I'm sorry, I just so I can understand the structure. You had a great big heading, refoulement. Now, these are your 7 points under refoulement. So this is Rwanda's capacity specifically as it relates to the risk of being refooled. Is that right?
It's specifically in relation to the determination processes in Rwanda, yeah.
So the chance that someone might have a defective decision resulting in them then being refooled.
That's what I'm on,
yes,
principally. I'm not dealing with general conditions in Rwanda or the allegations if they go as an arbitrary risk for that reason. I gave you the references to Armstrong 1 earlier on funding. Mr. Armstrong also deals with the intention to control flows and identifies, I think we've looked at the principal one in the MOU, there are provisions in the MOU and the note verbal to that end, i.e. the control flow. That's Armstrong 1, paragraph 16, Roman 7, about controlling the flows, and you saw earlier the provisions in the MOU that dealt with that. It's evident that the Secretary of State is therefore well aware that it will take time to build up Rwanda's capacity to determine significant numbers. No doubt that was why only a very small number, I think it was 47, were initially served with inadmissibility decisions and removal directions for that first flight. But there are safety valves built in if there are concerns in practice. No doubt the government of Rwanda can ask for assistance if it considers it needs it. They can always refuse to accept more transferees if the system is creaking, as it were. But the Joint Committee, you might also note, has a role in matching transfers to capacity. The terms of reference of the Joint Committee make clear that that committee is responsible for approving both the reports produced by the monitoring committee. You remember they're the body below that does all the assessments of how things are going on the ground, monitoring the end-to-end process, and also is responsible for approving what are called the indicative forecasts for numbers of individuals to be relocated to Rwanda under the MOU. So they're also involved specifically under their terms of reference with these flow issues. That passage is from Bundle 4, terms of reference, Bundle 4, tab 69, page 1351.
Well, Sir James, I think we are on the nose of 1 o'clock, so if that's a convenient moment, we'll rise now and resume at 2 o'clock.
All rise.